Hello everyone, welcome to Management 413 Employment Law here at the UAB Ch School of Business. In this video we will be covering benefits using Chapter 13 of our textbook. Here's the chapter outline. What benefits must an employer provide? What is this thing called ERISA and what does it require? And then we'll be looking at pensions, health insurance, and the risks of illegal discrimination when administering benefit plans. Employers are actually required to do relatively few things when it comes to what you might call benefits. Employers are required to contribute half of the Social Security tax. They are required to pay into unemployment insurance programs, and they are required to provide workers' compensation benefits. But there is no law that says that an employer has to provide health insurance other than the Affordable Care Act, which just went into effect a couple of years ago, as you know, that requires that some larger employees do so or risk paying monetary penalties. The general rule is that employers are not legally required to provide health insurance, pensions, paid sick days, severance pay, or other benefits. ERISA, the Employee Retirement Income Security Act of 1974, would govern a benefit plan if there were a benefit plan. ERISA covers pension plans and welfare plans. Pension plan is a plan that provides retirement income, and a welfare plan is generally going to be a plan for the welfare, for the personal welfare of employees, such as health care insurance. There are a number of benefits that might be routinely provided that are not covered by ERISA, such as vacation pay, scholarship, tuition plans, and things like that. ERISA is very notable in that it has sweeping preemption language. You may not, if you are a state or local government, try to dictate that employers provide certain pension or other welfare plan benefits. ERISA completely sweeps away anyone else from being in that field. Title I of ERISA is the main title that we are concerned about, that governs the administration of pension and welfare plans. What do you have to do under Title I if you're the employer and if you're going to be an HR professional and you're going to work in what is sometimes called the compensation and benefits area? This will be a big part of what you do. You have to advise employees as to what their benefits are. You have to deliver on the promises that you make. You have to provide a claims process for employees who make claims for their benefits and perhaps might get turned down. You have to manage benefits wisely as a fiduciary. Fiduciary means that you're acting in the best interests of employees and not in the best interests of the employer, and you cannot retaliate against beneficiaries of the plans. Look at the case in your textbook, Hilton versus AT&T, in which an employee of AT&T sued the plan administrators of one of that company's benefit plans when they denied her claim for benefits. One of the key features of ERISA is that benefits have to be described simply and with a minimum of legal ease. The document that is used is called a Summary Plan Description, SPD. The Summary Plan Description has to identify who the administrator is, what are the conditions for eligibility in the plan, what are the benefits, how do you claim benefits, and how do you appeal if you get turned down. You can sue your plan administrator if you are denied benefits. There might be an arbitration process set forth, but lawsuits do arise from turndowns of benefits. The standard for whether or not a plan administrator will be found liable is whether or not they abused their discretion. They are required to base their decisions on the actual plan documents. Employers have to provide a reasonable claim and appeal process. The standards for handling health insurance claims are somewhat more stringent, as you might imagine would be the case, because your health is involved, and if you get turned down for an insurance claim and can't get medical coverage, that could have some very dire consequences. The law sets certain deadlines within which decisions have to be made, and the deadlines are faster for urgent care claims. A fiduciary, as I said, is someone who has to act in the best interests of someone else. The people who administer employee benefit plans subject to ERISA are required as fiduciaries to manage the assets of the plans in the best interests of the beneficiaries using prudent methods. They have to diversify the plan assets, and they have to provide accurate information and disclose material facts. There is a simulation in question 6 in chapter 13 that will be assigned to a pair of you. The retiree who was not informed about the tax liability he would have when he accepted a certain type of retirement benefit and got a very surprising tax bill. ERISA also prohibits discrimination against someone, retaliation against someone who has exercised his or her benefits. ERISA also requires that there be a definite vesting period for receiving benefits. Prior to ERISA, it was possible for employers to have very, very long or maybe even indefinite periods that had to pass before someone had a guaranteed right to receive some sort of benefit, usually a pension benefit. Usually vesting periods subject to ERISA are 5 or 7 years. ERISA says that you cannot cut back on rights that someone has been promised in most cases under an ERISA plan. Here is a case in the textbook that I ask that you look at, in which a company or a union, I think it was in this case, attempted to amend a welfare plan in a certain way, and the court said, no, you can't do that. The ERISA anti-cutback rule says that that benefit could not be changed. A very important distinction for pension plans is the distinction between a defined benefit plan and a defined contribution plan. All of you as human resources professionals should definitely know the difference between those two types of plan. A defined benefit plan is one that guarantees a set amount after retirement. A defined contribution plan is one that does not have such a guarantee, but simply says that whatever you put in, you can take out. Defined benefit plans are increasingly rare, usually now confined to government organizations such as the Teachers Retirement System of Alabama, or maybe a very large employer such as Alabama Power. Most other private businesses have done away with defined benefit plans because they were too expensive, leaving employees only with a defined contribution plan. The Pension Benefit Guaranty Corporation was created by ERISA and will, if an employer has financial difficulty, in some cases step in and prop up the plan. Lawsuits can be brought by beneficiaries of plans. For example, one very common type of lawsuit is when an employer fulfills its obligations to fund a pension plan, not by putting in cash, but by putting in shares of the company's stock, and then the company's stock goes down, or perhaps the employees are limited in their ability to take out their money from the pension plan. A very famous case occurred in the early 2000s when the employees of Enron were locked out of their defined contribution plan because of a technical difficulty at the same time that the stock price of Enron, that eventually went out of business, was dropping dramatically, and they sat by helplessly as the value of their defined contribution plans went down and down. Here's a case against Fidelity Investments, a fiduciary to a 401k plan for a company called ABB. The beneficiaries of that plan sued Fidelity for breaching its fiduciary duty in setting fees that were, or charging fees that were too high, and Fidelity won and the employees lost. The Patient Protection and Affordable Care Act, as we all know, was passed into law in 2010. It is the signature healthcare law of President Obama and is sometimes called Obamacare. Its primary purpose is to make sure that most Americans have affordable health care. Also has a number of provisions that are designed to keep down the cost of health care. This is a very complex law. Most companies obviously had health care insurance plans prior to its passage, and they might be exempt, but as time goes on, more and more companies will have to comply with it. There are a very large number of provisions of Obamacare. Look at this list in terms of who is required, who is subject to it. Employers with at least 200 full-time employees who offer health care insurance covered are now required to enroll all new full-time employees automatically. There's another requirement not imposed on the employer, but on individuals. Individuals who fail to obtain minimum essential coverage for themselves or their family members are now subject to a monetary penalty. You're probably aware of that. COBRA. COBRA has nothing to do with snakes. Somebody thought it would be funny back in 1986 to call a tax law the Consolidated Omnibus Budget Reconciliation Act. And if you spell out the first letter of each word, that spells out COBRA. One of the provisions of that law was designed to make sure that when people leave or have other certain events occur in their lives, that they can continue to have health insurance. Generally, for those of you who become HR professionals, the way COBRA will come up is whether or not someone leaving your company is entitled to continue his or her insurance coverage. We will have a simulation on this. Chapter 13, question 3. COBRA does not apply when someone's employment is terminated for gross misconduct. And was this flight attendant who was terminated for fighting with another flight attendant guilty of gross misconduct and therefore not entitled to continue her employment, her health insurance benefits? A key aspect of COBRA is that employers have to give notification to the right people about their health insurance when these events occur. COBRA is not free. Just because your health insurance continues after you leave a company does not mean that the employer has to pay for it. You might be charged up to 102% of the cost that the employer has to pay. You have to pay that out of pocket, even if the employer used to pay for it. Medicare provides for a substantial payment of health insurance costs for those who are 65 and older. Particularly in years gone by, many larger companies would agree to provide for post-retirement health insurance for their retirees. That has gotten extremely expensive, and now fewer and fewer employers provide for post-retirement health care. Older workers are more expensive to insure than younger workers in health insurance. Companies, employers are permitted to provide less extensive coverage for older workers as long as the amount expended, however, is the same as that spent on other workers. My experience is that very few companies charge more for coverage to older workers than younger workers. HIPAA. Some of you have perhaps heard of HIPAA. Its full name is the Health Insurance Portability and Accounting Act. It's most famous for its privacy provisions for your medical information, but it also does a certain number of other things. It, for example, had some provisions on pre-existing conditions, but most of those provisions have been superseded by Obamacare. The primary thing, apart from privacy of health insurance for you to remember about HIPAA, is that it prohibits health plans from denying benefits or charging more based on a particular health factor. The Mental Health Parity and Addiction Equity Act says that there should be some parity for mental conditions, insurance coverage for mental conditions as compared to medical and surgical treatments. And we have already discussed the Pregnancy Discrimination Act, which is an anti-discrimination act and is not a coverage act. That is it for this set of slides. In our next learning module, we'll be looking at unions and collective bargaining.